Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case.
Dati mihi Anglican boys, verbal fluffy.
That's literally not true.
Is that correct?
Oh, for crumb's sake.
I didn't ask you to interrupt me.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. We are back for the lunch hour special. It's a working lunch. Feel free to bring your popcorn, your drinks, everything. It's casual Friday already, so no worries there. I don't know who won chat, but I think it might have been Denisha Blyther. Was that you? I couldn't. If it wasn't you, I'm sorry, but just let me know. Was it you, Denisha? Couldn't tell who was first in chat. It's as far back as I could scroll. Oh, it was Kim. It was Kim. All right. Sorry. Kim, I apologize. I should have known. That's Denisha, we'll give you a break and we'll pin Kim instead. Turn that down just a teensy bit. Sweet potato fries, everything welcome. Good. Kim, you know the deal. First in chat, you're getting punished. Internet ownership, it's all your responsibility. Everything IP related worldwide, you are going to have to maintain, fix, install, repair, and train the use of. So good luck and good riddance. Glad I can just dust my hands of that responsibility. Laura Simpson, it was definitely me. Marianne, I was number 2, almost made it. Soon. Cody got lost in the portal, but you're here now. It counts. Shirley Knott says I'm in Idaho too early for lunch. Well, you can have second breakfast then. Can we sit? Yes. Let me let you sit here really quickly. I have to turn this off. Lumia's stream is acting a little funny, possibly because they just released a new patch and they keep deactivating the old ones. So installing the new one. Let's see if it has in fact updated. Well, 8.9 beta 1. I think we're good. It's working. Mike just got some extra points. Congratulations, Mike. All right, so with no further ado, we're going to jump right into where we left off. Let me just explain. We have a pro se defendant in court here in Tennessee in front of Judge Wolf, who is arguing for himself, and he has the help of what's called an elbow counsel. I call it a pocket lawyer. They call it an elbow counsel. Basically, a lawyer standing by, sort of helping and advising and consult with, but he's running his own case. He just successfully argued to allow the lawyer also to argue for him, which is just crazy. And right now he's questioning a officer who responded to a domestic disturbance call and arrived to find him driving a vehicle, and he was belligerent and resisted arrest and got arrested for that. And he's questioning her about that and about the intake process of the jail, where Mr. Vaughn, yes, let's pin him up here. Mr. Vaughn, I'll put that on the screen again. He's questioning what the officer did. In this particular part where we're picking up is where the officer assisted with taking her handcuffs off him as the jail handcuffs remained on him, and that's what basically where we're picking up right here. So just one second.
Or was I putting up a fuss or fight with them at this time when you intervened?
Yes, sir.
You stated that the reason you didn't take the handcuffs off when you came in the jail because I was in their custody. That means that your responsibility ended at the time, correct?
I'm not just going to stand there and watch somebody fight and resist from someone and put them in any type of danger. No, I'm not.
What do you call fighting and resisting? What does that look like to you? In your own words, please.
Can you
thought I was
clarify?
muted for that.
What does fighting and resisting look like to you? Like if you see somebody fighting and resisting, what does that look like to you in your own words? Can you paint the court a picture, please?
Resisting would be preventing them from removing the handcuffs is what was happening.
So pulling away, maybe arguing. Okay.
Making those threats, pulling away, tensing up to where they couldn't remove the handcuffs.
Okay. You stated that earlier
Grab my lunch. I'm listening.
along the lines of, I made the statements of, I'm going to beat you up, B, correct?
Yes, whenever she was asking you to stop tensing up, that is what you said.
Was I speaking to you?
You said that out loud. You did not say that directly to me.
Oh, so
but
I
was
didn't
right
direct
there.
it to you, but you believed it to be towards you?
Absolutely.
Okay, do you also recall? You made a statement, it's on my other notebook. This one? You said you made a statement to me as we entered the jail when you said that I allegedly said that I am a threat. You made the statement. You said like you was threatening me, but it's cool. What do you mean by that statement?
Whenever I was walking up to the jail counter, I made the statement that I think, if I recall correctly, you said something about not threatening, and I said it seemed like a threat to me, but it's cool. If I recall correctly, that's how it was said.
Yes, what did you mean by it's cool?
That it's fine. I mean, you're going to threaten me. Later on, you made very thorough threats.
Let's stick to the question I'm asking you. So what you said it was cool. Like, does that mean you feel harmful? Does that mean that, well, oh, that ain't nothing, you're just talking, or what does that mean to you?
It's cool. You made the comment. It's cool. If that's what you want, do you want me to answer?
You can go ahead.
Okay. What I was saying is that it's cool. If you want to threaten me, then you can threaten me.
You just blew it off your shoulder, basically. Would you please use your words?
You stated you were a threat. I said it felt like a threat, but it's cool.
So you blew it off, yes, correct.
I'm not saying I blew it off. I'm just saying that it's cool. If you want to threaten me, you can threaten me.
Did you feel threatened at any time?
During that whole encounter, up until me leaving the jail, yes.
So do you normally laugh when you feel threatened?
Sometimes. A little uncomfortable.
When you feel uncomfortable?
Yeah.
Okay. So do you recall the statement, he's just acting tough, he's just acting bad? Is that normally like a fearful statement?
I believe that your demeanor changed from the time that we were coming in. Like when we went into the jail, your demeanor changed. And then when you believe that when they were trying to take the handcuffs off, you were acting completely different, yes.
Do you believe that I would actually retaliate against you?
I do.
You do?
Yes, sir.
So if you believe that, then why did you take so long for the charges to get filed for retaliation? It's 5 months after your arrest.
To be completely honest with you, I didn't know that was a thing. If you want me to be completely and totally honest with you, when they made me aware of that, I was like, oh, I didn't know that was something that could be added on.
So it took you 5 months to figure out that you felt in harm and fear?
No, I did not know that retaliation
Mr.
after
Vaughn,
the fact was a charge that could be used.
To explain that, she didn't bring the charge. The grand jury returned this indictment. So it's not that she went to a magistrate and obtained a charge 5 months afterwards. The new charge was added by the grand jury when it was considering the driving on a revoked license and the resisting arrest. They added the third charge after hearing testimony.
Well, what I want to ask her next was, why didn't she file it then? You had 5 months. She made it in her statement. Her statement was on time.
Then ask that question.
Okay. So once you found out about the resisting arrest, that it was a possible charge that you can charge, why didn't you file it?
I was well aware that resisting arrest is a charge.
You was well aware that it was?
Resisting arrest? Yes, sir.
No, I'm sorry, excuse me, retaliation.
I was made aware during the grand jury proceedings.
Okay, so that's why you didn't file it, but you just took note of it in your report. That was the only reason, just for future reference.
For the notation of the threats that were made in my original report, yes, sir. I notated in there just in case some further incident happened. Absolutely.
Okay, was there ever any actual retaliation tried by me or anyone?
I've never seen you other than that incident and in court.
No calls, no threats, no nothing, no contact whatsoever?
No, sir.
Okay. But you believe that a retaliation was still possible?
Absolutely.
Okay. How long after the encounter with me did you decide, before you found out that I was allegedly driving unrevoked?
What are you asking?
After the first contact you made with me, how long did it take you to find out or find an alleged driving unrevoked charge? Was it before you placed me in handcuffs or while we were at the jail?
While we were still on scene. I met with the magistrate before we ever went to the jail.
You met with the magistrate before we went to jail?
Yes, sir, at the police department.
Yes, that's when you found out it's at the jail?
No, I found out on scene that you were revoked from dispatch. So at the time that you were transported, I was well aware that you were revoked.
Okay, would you say it was about 15 minutes, 20 minutes maybe?
I don't know the length of time, but I know prior to you being transported, I knew that you were revoked.
Okay.
May I briefly?
You may.
You're fine. It's Lindsay Javens.
Your rank, I'm sorry.
Oh, corporal. I'm sorry.
Okay, I always do that. So when you say on scene, you still consider the the police department to be on scene until you actually get to the jail, is that?
No, sir. I'm saying on scene as in Dollar General. I knew he was revoked before we left Dollar General, before he was transported to the jail to meet the magistrate.
Okay, all right. And that is driving on revoked or suspended, that is a catch and release statute, correct? You could have issued a citation, correct?
Oh, okay. I see what you're saying. We can issue a citation unless it's significant numbers. There's clarification of time that we can and can't issue citations.
Significant numbers, was that?
Like if someone has 4 priors or 5 prior driving unrevoked, that's indicating that the likelihood of the offense is going to continue if they continuously are getting driving unrevoked charges.
Okay.
So that is an exception to the citations.
Did you note that in the warrant?
I'm not saying that that was applicable in this situation. I was saying that that's a time that they wouldn't be arrested.
But if somebody,
they would be arrested, not a citation, sorry.
Right. And Miss Dozier, she was, Dozier, I'm not sure, she was present, right?
Yes, sir.
Did you run her driver's license?
I believe so, yes, sir.
Was it valid?
I do not recall.
Did she drive off from the scene?
I do not recall.
She wasn't placed in custody, though.
She was not taken in custody, no, sir.
So, in theory, she could have driven away from the scene in lieu of Mr. Vaughn, right?
If she had a valid driver's license, yes, sir.
And you issued the warrant primarily on this resisting theory.
Resisting and driving unrevoked.
Okay. But you determined the resisting first, right? You determined that you were going to charge with the resisting first in time that night. Then the driving unrevoked.
They were presented to the magistrate at the same time. He was...
But you, in your mind, you witnessed what you would say. Did you run his driver's license before you placed him under arrest for resisting?
I believe that he was placed in handcuffs after I got him out of the vehicle and put him at the car. The point where he was transported to go meet the magistrate, I was well aware of the driving unrevoked and the resisting.
Okay. You didn't run her driver's license?
While on scene, I typically would log all parties, so I believe that it was logged. I just don't recall if she was valid or not.
Okay. But your report says you couldn't determine who the aggressor was in the alleged domestic, right?
I could not determine that, or the primary aggressor, and that an assault occurred for the domestic.
Okay. So absent this resisting charge, it's likely that you would have issued him a citation and let him go, right? Had he not done what you perceived to be resisting arrest? And let her
Possibly so.
drive.
Possibly so.
That's possible.
Possibly.
And had he not been out there cuffed up in handcuffs, these statements are never made, this evidence is never obtained, is it? For this charge that you didn't know existed, correct?
Can you clarify what you're asking?
If he's never arrested for resisting arrest, and he's issued a citation in lieu of arrest, and Ms. Dozier is allowed to drive away from that scene, and Mr. Vaughn is never in cuffs and taken to the sheriff's office out here where the jail is, correct?
Yes, sir. Correct as in that's where the jail is.
Well, in that scenario, he never would have been taken there that night by you either. That's correct, isn't it?
He was taken in custody for driving unrevoked and for resisting. That was presented to a magistrate and probable cause was found, warrants were signed.
Understand that, but that's what I'm asking you. You would have been able to issue him a citation if not for the resisting charge, right?
You're asking a hypothetical situation. I'm telling you what occurred, that's what occurred.
Asking you, okay, then let me ask you specifically, had he not resisted, would you have issued a citation?
I could have possibly issued a citation.
Would you or would you not have?
Depends on the situation, the circumstances, how many priors he had.
The circumstances as they were that day, how would you have done it?
The circumstances how they were that day, I would have done the same thing that I did.
Absent the resisting portion that you claim was resisting, and you came up there and nobody wanted to talk about you about what you perceived as a domestic, would you have just simply issued a citation to him? Take out the resisting part.
Yes, sir. Like I said a second ago, that is a possibility that could have happened.
Okay. And had you done that, he would never have been cuffed up, would he? In the event that you had issued a citation, right?
Are you saying that he never would have went to jail? Is that what you're saying?
Yes.
Yes. If I issued a citation, I do not take someone to jail. That is correct.
Okay. And at that point, you're not having to get your handcuffs back, are you?
No, sir.
And he's not making those statements, is he?
If we're not at the jail, that's a hypothetical situation. If he was not issued a citation, if he was issued a citation, we would have never been at the jail.
Okay.
That help?
And you have count two, that resisting has been dismissed, right?
They elected to dismiss it, yes, sir.
Okay. And you put your hands on him, and all he said is, "I'm not getting out of the car," right?
I
You opened the
door, and then we got out of the
put your
vehicle.
hands on him. At which point, Mr. Vaughn then showed you before you do that, before you do that, he had a weapon on him, correct? And he showed it to you. Was there a knife?
Yes,
right?
sir.
So he was making sure that you were aware of the circumstances, right?
Yes, sir.
And so you didn't misinterpret his intentions that night, correct?
Misinterpret what intentions?
Well, he wasn't charged with an assault against you, and a knife can be considered a deadly weapon, right?
Yes, sir.
So if a suspect concealed a knife, then that would be a charge. He didn't conceal that from you at all, did he?
He made me aware that he had the knife.
Okay. And had he not, and you found that on him, that could be a basis for some sort of assaultive offense, right?
For having a pocket knife?
If you were afraid of it.
No, sir, I would not say that would be an offense or an assault to have a pocket knife.
But he was being cooperative and telling you in advance that he had that knife.
After the fact, yes, sir.
Okay. And you did go out there and said it's cool after he talked to you the first time, right?
After he told me that he was a threat?
Well, after what you say, he said, sure, if that's what you say, he said, you said it's cool.
Yes, sir, that was before the next two statements.
Okay. But at that point, you didn't feel threatened by saying if you said it's cool.
He said I'm a threat.
And you said it's cool, which would not be indicative that you felt threatened, would it?
No, sir.
Okay. And you, I believe, said that you became threatened after Corporal Stewart made you, or you felt more threatened after Corporal Stewart told you what he said after you were gone, right?
No, sir. That's when we spoke about what he told to Corporal Stewart as well. That's whenever we talked about making sure that it was documented in the report.
Okay, so Corporal Stewart's statements about what he said, those didn't play any factor into you adding this charge at grand jury?
It contributed to the whole circumstance, yes.
Okay. And you heard Corporal Stewart testify the other day, right?
Yes, sir.
Okay, and you were not, your name was not mentioned specifically whatsoever in what Corporal Stewart heard. All that?
There were no names mentioned to my knowledge.
Okay. And so there was no direct threat made, indirect or direct threat made at you specifically, based on simply based on what Corporal Stewart heard and testified to.
If I recall correctly, he testified that he took the threat to be to law enforcement.
But law enforcement's not named as the victim in this indictment. You are.
I am law
specifically.
enforcement,
Okay.
technically.
But you're the only one that's named in this indictment.
Okay.
And your name was not mentioned specifically whatsoever.
He did not specifically say my name, no, sir.
Okay. And you're only, and you said you ran his driver's license on the scene at Dollar General
Yes, sir.
before you went to the police department?
Yes, sir.
To the magistrate? And I know I've gone over this, but you had already had in your mind that you were going to charge him with an arrestable offense, right? That's why resisting arrest, you're going to get warrants. You saw what you perceived, at least, as resisting arrest on that scene, right?
Yes, sir. I believe that he was resisting and he was driving unrevoked. He was taken in custody and that was presented to the magistrate.
And the resisting would nullify nullify the practicality of issuing a citation for the driving on revoked, because you're cuffing him up anyway for resisting.
As I said, that's a hypothetical situation. That he could have been issued a citation, yes, but there were other things I would need to look at. If it fit any of the exceptions, then no, he wouldn't have been issued a citation.
Well, he wasn't going to be, because you were going to arrest him for the resisting. So it wouldn't have been a need for a citation anyway, would there?
What
Brad,
do
I
you-
think you've asked that question about 5 times.
Yeah.
And I've not, believe Your Honor, gotten a direct answer.
She's answered it in the form of that under the facts of the circumstances, this is what she did. If she could have issued a citation, she said that. If she'd issued a citation, he would not have gone to jail. If he hadn't gone to jail, he might not have been charged with retaliation. All of that, you've made that point several times. Is there some other question that you want to ask?
No, Your Honor, not specifically on the point. I just wanted her to answer me as to the citation was less likely to be issued because she had what she perceived as an arrestable offense. I don't think I've gotten a straight answer to that.
Well, with the citation,
No,
I'm
you go
sorry.
ahead. You got it.
With the citation being issued, if I'm going to issue someone a citation, I have to make sure that it doesn't meet those exceptions. If it meets those exceptions that are outlined in the law, then I can't issue a citation, and I should take them in custody.
Did you go through those exceptions that night?
No, I did not, because there was resisting and a
Okay.
driving on revoked.
I think that's what I was asking. So.
But you're at like a hypothetical situation of, for sure that I would have issued a citation. I can't say that. I absolutely would have issued a citation. If it met those situations, the exceptions in the law, then he would not have been issued a citation.
But you never got to those exceptions because you had, I mean, I think that's what you just said. You never checked those exceptions because you were arresting him for resisting.
He was arrested for both, yes, sir.
Okay. That was my question.
I don't know why the elbow counsel was allowed to tag team that questioning. But
Is laughing sometimes a form of de-escalation?
Yes, ma'am.
Now, you talked about those exceptions under the law. One of the exceptions to citation in lieu of arrest is if someone, if there is a reasonable likelihood that the arrested person will fail to appear in court.
Yes, ma'am, that is.
And you didn't look into how many FTAs Mr. Vaughn had because you were already arresting on something else. Is that right?
That is correct.
If someone has multiple failures to appear on their criminal history, would you issue a citation in lieu of arrest or would you arrest?
I would arrest if there was a likelihood that person would not appear in court.
Nothing further, Judge.
Anything further for this witness?
the active shooter situation was a false alarm. For those who are curious, in UNC Wilmington.
Corporal Dravens, you have been asked by both the defendant and elbow counsel multiple times on the timeline of when you realized that the defendant was revoked. Have you watched your entire video start to finish to be completely sure of the exact moment?
No, ma'am.
Do you even know if it's going to be on your video when you find out that he is revoked?
It could be, but during the investigation, I ran, his license, and I was informed, and I know that was before I would have went to meet with the magistrate.
Yeah, before you went to the magistrate, you found out that he was revoked.
Yes, ma'am.
But you don't know exactly what moment.
Not the exact moment.
So just throwing out the possibility, it is possible that it wasn't until you got to the police department with him.
Yes, is the right answer.
Could be, but I would say that I knew on scene.
Okay. Nothing further, Judge.
All right. Anything else?
The same question she just asked you about the time limit on the arrest. Would you say 30 minutes is roughly too long to find out if someone's driving on revoked?
No.
I don't have a timeline on the amount of time that I knew that you were revoked.
Is there any policy or proper procedure that you go by to stay in lawful to a pullover?
Well, I cannot detain someone for longer than reasonably necessary, if that's what you're asking.
Okay, would you say that reasonably necessary after I was placed in the back of the car and we were leaving the scene, do you think that would that be considered a reasonable time?
Can you clarify what you're asking?
Once you decided to place me in the back of the car and we were leaving the scene, would you consider the investigation done, that was the reasonable time to end the investigation?
Kurt, welcome.
Or should we take it to the police station and continue an investigation?
Glad you're still with us.
You were taken in custody and it was presented to the magistrate. I'm not sure what you're asking.
Virgil, welcome.
You're familiar with
Thank you so much for joining us.
what you think a reasonable time would be, correct?
This is a silly argument.
Depends on the circumstances.
Okay, so do you believe that when we left the scene that the investigation should have been concluded?
You were taken in custody.
Yeah, so does that mean that the investigation prolongs after that custody? I mean, if you choose to investigate anything, are you required to, I mean, do you feel permitted to go on further past that? If you take me into custody and you want to keep investigating, is that okay?
Can you clarify what you're asking?
All right, when we left the scene and got to the police station, is it okay to continue to investigate?
Yes.
Absolutely.
Okay.
Absolutely.
So what I'm asking you is, when we left the original scene before we got to the police station, you were not finished with your investigation?
You were taken in custody and you were transported there. If I didn't know that you were, I believe that I knew on scene, but if you're implying that I didn't know until we got to the police department, they were presented to the magistrate at the same time. I don't know that that's relevant.
It is when it comes to, well, I can't make statements. But that'd be all, Your Honor. One more, I believe, my assistant.
No.
I allowed him to assist by asking a couple of questions, but that's not the role of elbow counsel. The Tennessee Supreme Court in State versus Small, which is at 988 Southwest 2nd, 671, defined the role of elbow counsel. When you have elected to represent yourself, then you have waived your constitutional right to counsel. It is within the court's discretion to appoint elbow or assistant advisory counsel, which I have done. And the role of a advisory counsel, also known as elbow counsel, is an attorney who functions in a purely advisory role to a pro se defendant without actively participating in a trial. Pro se defendant who is permitted such counsel may consult with the counsel for guidance and advice, but otherwise handles the defense of his case on his or her own. So Mr. Spratt can sit there and give you advice, and that is his role. He's not going to be allowed to question witnesses and otherwise make statements or have any other role other than giving you advice, because you have waived your right to counsel. So.
Okay, can I seek advice from him then?
You may.
Sloth Life, thank you for your generosity. 5 gifted memberships. Wow. So the judge reads the law and says, I shouldn't have done what I just did, and allow him to ask questions. Says, I'm not going to allow it going forward. Clearly, this timeline is very important to the defendant. And if I hadn't been arrested for resisting arrest, which was dismissed, then none of this would happen. So because it was dismissed, none of the rest should happen. Unfortunately, that's not how it
Your
works.
Honor, I'm going to ask you permission to read, since Ms. Daniel Bryson brought up the video, that I'll be allowed to play the video in open court.
Do you have any other questions for this witness? You want to play the video in your response to the state's evidence? Is that what you're saying?
Yes, sir.
State have any objection to that? Then we'll allow that to take place. I just want to allow the officer to step down if you have no other questions.
Can we see it, Judge?
Is it possible that I could play the video to ask her further questions about what she views in the video?
Let's let the officer step down. Do you have any other witnesses?
Judge, I think the video may be being played at attempt at impeachment, and so if so, she would be able to respond after it's played.
Well, let's bring the video up and let's get it hooked up, and we'll allow it to play it if it's part of his cross-examination.
I hope we can see this one. Roll that beautiful bean footage, right? Judge Wolf is, I think, running low on patience today. He's so frustrated with this pro se guy, who's obviously there's more obstinate.
Who hasn't?
Who has the video? Why is no one bringing it forward?
Who is playing it, I guess is my question. Mr. Spratt?
They're all sitting there. No one's doing anything. I think the prosecutor knows that that this witness, the officer, the arresting officer, is not going to be successfully impeached by this other than possibly when she found out when he was revoked. Because clearly the prosecutor was throwing her a lifeline. Isn't it possible this might have happened later? The answer is yes, it's possible. Unless you have a distinct and firm recollection that it happened at a certain time. Instead, she said, no, it happened before I left the scene. That might be proved wrong, which would be for impeachment. But who has the VHS? Who borrowed the VHS player? And who didn't rewind as well? Be kind, rewind. Happy Friday to y'all, everybody. Appreciate you being here. Hope you have a wonderful, wonderful weekend lined up. Okay, we're looking for the HDMI cable now. What's up? Please tell me it's not playing right now and we can't see it. That would be terrible. Judge isn't watching, so I don't think it's playing right now. Corporal is 2 stripes? 2 chevrons? What's that on her sleeve? She's got 2, and she said she was corporal, right? It's an 8-track. We've got a reel-to-reel and an 8-track we have to sync up together. Just give us a minute. Cannon fodder. Oh, man. You've got to find opportunity to go sit in Judge Wolf's courtroom. He has some amazing stuff. Some of the adoption stuff he does. He's one of my favorite judges to watch there. I think he stopped actually televising those, live streaming those. But he's a great judge. Tons of experience.
I'm going to step off, take a short recess while we try to get this queued up.
We're going to fast forward.
Let me know when you're ready.
All rise.
They get higher. It would play like Whose Line Is It Anyway? You know, just like a... Okay, we're going to fast forward a little bit. Look for the judge to come back in. Oh, they've got it playing, but the judge is not here. So we wait for the judge to come back. 3, 2, 1. There he is. Okay, here we go. We are going to see this. Back on the record. And the video is on the bottom that you see here. We're all set to watch this. Not sure if this is dash. Probably body cam, I think, actually. And possible language warning. I know he says he was a little agitated at the time, so. The judge went back into his chambers and utilized his screaming pillow. Bree, yes, they can. They can see registered owners and license status of registered owners. Basically, everything that's in a database that the state has on you regarding your vehicle is accessible to officers in their car. Depending on your jurisdiction as well, some cars, some police cars have basically AI or camera systems that are set up that are constantly monitoring all the vehicles around them. So they're looking to the left and forward, to the right and forward, and straight ahead. And anytime they recognize, using object recognition, a license plate, it will run it. It will run it, and there's just a running total in the car of what it's run, and then it will, there can be an indicator, a flag, an audible or a visible alarm on the computer saying, "Hey, we've got a hit. There's a warrant on this car," or this is a stolen vehicle. A lot of people, a lot of I would say fugitives don't like that. There's been arguments that that's unlawful, but I think it's upheld the challenge thus far at any Supreme Court level. I think Kurt you might be able to tell me better on that one. Carolyn, welcome to the gallery. Thank you very much. I've got a few other people I need to recognize that I think I missed last time. Sherry K, member for 5 months. Thank you, Sloth Life. Thanks for your generous super chat, as well as the 5 gifted memberships. Virgil James, welcome to the gallery. You're one of us now. You can never leave. Thank you all. It's not showing all the messages, possibly because I had to reboot it. I found Halloween screaming ghosts at Walmart. I emailed a picture. They scream and play spooky music. That's pretty much my role at Halloween. I set up my sound system with a wireless mic and run a few effects on the soundboard to make it sort of like a chorus of voices instead of a single voice, with some echo and stuff. And then I scare the little kids. What are we waiting for? I'm going to fast forward a bit. Clearly, elbow counsel and prosecution is not here yet. Oh, now they came in. There they go. This is mostly screaming.
Let's dim the lights.
Oh yes,
Please.
Mood
Ready when
lighting.
you are, Your Honor.
Ready.
Mood lighting. Here we go. No necking, guys. No necking. That's what my science teacher used to say when we watch a movie. Junior high. Nope. I'm gonna get a strike. I can't do that.
Hello. Good. How about I come back here and talk to me real quick, man?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
what's for a domestic?
Yeah.
What makes a domestic?
I got you. Somebody just called. Let me come back here and talk to you real quick. We'll talk about it.
I can't step out of the vehicle until I commit a crime. I reserve all my rights.
All right. Well, let me tell you this. So Pennsylvania versus Mims case law says anytime I tell you to step out of the car, you step out of the car.
But you also know.
Case law says. No. Case law says if I tell you to get out of the car, you get out of the car.
Can I have a male? Can I have a supervisor come to the room?
Well, they're coming. You're going to get out of the car when I ask you to.
I don't feel comfortable right now because as a female person, it's a male domestic. I've been in this many times.
I'm just trying to talk to you. Okay. You're making this a thing.
No, I'm not.
Step it up for me. I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're going to talk to you separately. That's how we're going to go. So I'm going to get you to step out of the car. Look, this is going. You're going to step out because I'm telling you to step out now.
Where am I going to stand? And am I under arrest because I step out of my private vehicle?
You're not under arrest right now. I just need to talk to you.
I have no reason to step out. I'm still not under arrest.
Step out. You're going to go to jail for resisting. The second I put my hands on you and you don't get out of this car, you're going to go for resisting.
You do not answer correctly. You know this.
There ain't nothing about it. I just told you.
I'm not under arrest. You have no reason to touch me.
Case law says if I tell you to get out of the car, you get out of the car.
If you say I'm under arrest,
get out of the car. Come on. Get out of the car. Get out of the car.
That's an annoying noise.
I need you to get out. Get out of the car. Don't get out. Get out.
Well, hold on. Grab that before you touch me.
You're good. Ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's 2 males in that car.
I want a male to touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's going to be a male that's going to touch you. Put your hands on your back.
Please touch me.
There's going to be a male that's going to touch you.
A male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
See, you're being disrespectful.
You've been disrespectful since I
asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Why am I detained?
Did I tell you to get out of the car? Did I tell you to get out of the car?
Am I under arrest? Am I under arrest?
Did I tell you? Now you are.
I reserved my rights.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think.
All right, ma'am. You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got you.
Another 15 years.
I got you. Well, there's enough that's already. Listen. There's a.
Your Honor, I would like to stop that right here and request now the time to ask some follow-up questions.
All right.
Improper impeachment, but.
Officer will return to the stand.
Your Honor, I would also like to request that the courts move that into exhibit as a hearing.
As a hearing?
We will mark it as an exhibit to this hearing after the conclusion of the playing whatever portion you intend to play. In the state may elect to play more of it. We'll see. But you may go ahead.
Okay. Up to this point of the video that you've seen, would you classify that as the resistance that I was arrested for?
Yes, sir.
You would. At this time, did you go through the cite and release or the arrest? Yeah, the cite and release. Did you have time to go through it then?
At that point in time, resisting. I asked you to step out. I told you when I had to put hands on you to get you out. And whenever I reached to get you out, you jerked away from me and then went to get out.
I jerked away from you in that video?
You pull away. As soon as I touch you, you pull away. I mean, if
you sure I wasn't reaching for a seatbelt that was across my chest to unbuckle the seatbelt and get out of the vehicle?
if you'd like, I mean, it's up to you if you want to play it again.
It's up to you. I'm the judge. If he would like to see it again, I'm familiar with it. It's up to you if you would like to see that again, Your Honor.
Do you want to see it again? I don't think it's necessary that we replay it again. She's answered your question, and this is not an argument between the two of you. This is question and answer form.
Yes.
So ask your next question.
One second, Your Honor. May I speak to my counsel?
Okay.
It's a really nice Halloween costume. The ankle chains really complete the look. Counsel's like, yeah, well, you're pro se. What do you want to do? It's not my problem. It's your case. So the question is, did the officer have probable cause to remove him from the vehicle? Does he have to be arrested to be removed from the vehicle? Or does the allegation of domestic and the subsequent investigation where they have to separate the two parties to see if something actually happened, is that sufficient? She said, you're not under arrest yet, but you have to step out of the vehicle so I can talk to you. Meaning I've got to have your story separate from her story, which is common practice for the police. But can they make him get out of the vehicle? Don't know. Have to see what Tennessee law is. Him saying no, I can see why resisting was dropped.
The segment of the video that we just viewed, so would you agree that I was arrested for refusing to get out the vehicle at this point?
For resisting, yes.
Yes, that's the only thing I was at this point in the vehicle. So there was no other offense up to this point?
At the point where we're paused right now, there was resisting. I said you're going to be arrested for resisting at minimum.
Okay. I believe that's all, Your Honor.
All right. Are we playing any more of this video?
Elbow counsel's like, please.
Right.
I did
Thank
not
you,
go to law
Officer.
school for
Do you have
this.
any further questions for the officer? Thank you, Corporal. You may step down.
Yes, sir.
All right. You may call your next witness.
That's the case law she was talking
General
about.
State is putting on their proof. On On this 336 indictment, the state has rested their proof on your motion to dismiss or suppress. You now have the option of putting on proof of your own. Do you wish to offer any proof?
Yes, I would like to make a note of the video first, Your Honor, if I could.
You want to?
I want to clarify that that was just the first 3 minutes of the video.
Right, that's fine. Well, we're going to make the video an exhibit to this hearing.
Excuse me, Your Honor, I didn't hear that, please.
We're going to make the video an exhibit to the hearing, and you're going to have to designate the first 3 minutes. Is that what you said? Is the portion you're relying upon?
3 minutes and 6 seconds, yes, sir.
3 minutes and 6 seconds are the portion that we're relying on.
That
you're relying on.
Yes,
right.
sir.
Then it'll be noted on the record.
I think resisting arrest cannot
I would
be.
like to call my witness now at this point.
It cannot be the charge.
Jennifer Dozier.
All right.
You can't resist the arrest for resisting arrest and have that be the only charge. There has to be a primary arrest to resist that arrest, right? There has to be a reason to take you into custody before you can resist. Now, you could probably should have better charged that as impeding investigation or something along those lines. There's a million different charges that could be filed that way. Saying, hey, I've got a job to do, and you're not allowing me to do it by refusing to get out and talk to me about this. But probably overcharged on that one a little bit. Impeding investigation, yeah. But she arrested him for resisting, and that's why it was dismissed. So he's trying to say that everything subsequent to that is basically fruit of the poisonous tree, right? She didn't know that he was revoked, which she could have arrested him or ticketed him for. But she didn't know that yet. So they're trying to say that the arrest was improper. If the arrest is improper, then all this gets thrown out. He might win.
Tell her to come in, put out her cigarette, and come in now.
We need that soundbite. Your Honor, the witness is out back smoking. Well, one last puff, and here we go. Just hit my sales goal for the day. Amanda, congratulations. That's awesome. And the day's not over. Maybe you'll get one more sale. Or 2 or 6. My Halloween story is not a good story. I was trying to make small talk.
Excuse me, Your Honor. While we're waiting, is it possible that I can recall Javins and ask one more question, please? And my proof?
Judge.
Days had rested and you had failed, but I'll allow her to come back to the stand for you to ask one more question.
He's like, you failed to, you didn't subpoena her, and you didn't, no, yeah.
Officer Corporal, I would remind you to remain under oath.
Yes, sir.
This better be good. Came from elbow counsel.
At any time, did you Mirandarize me?
I'm sorry, repeat that.
At any time, was I Mirandarized?
Mirandarized. New word.
Were you what?
Mirandarized. Did you read me my Miranda rights?
There we go. That's
Not that I recall.
Not that you recall. Is that normal procedure too? When you're going to arrest someone to read their Mirandarization?
Not every time, no, sir.
Not every time. With this situation, would you say cause for it? This arrest, pertaining to this arrest?
Pertaining to this arrest,
Would
no,
you-
I didn't need to, I don't think that I was asking you any questions related to resisting or driving on revoked. If I was asking you questions, if you were being interrogated, you would need to be advised of your Miranda rights, but you were not being interrogated.
Okay, thank you. That's your honor.
or questioned.
Thank you, Corporal. Hopefully this time you can stay seated.
Yes, sir.
Mirandarized, new word. going to be on the spelling test at the end of the week.
Dozier, I need you to come around to the witness stand, please. And ask you to raise your right hand and let the clerk place you under oath.
Miranda, rise and shine, everybody.
Thank you. Have a seat.
Tracy, what's up? How can I help?
Mr. Bond, she is your witness, so you may approach the podium and question the witness.
Okay.
Bless you. Oh. Everyone's got it. I need to wash my earmuffs now. She's been authorized, so you're ready to proceed.
Would you state your name for the record, please?
Jennifer Nicole Dozier.
Okay. Can you hear her, Your Honor?
Barely.
I'm sorry. I started this 2 days ago and it still hasn't cleared up.
Just pull that microphone to you as close as you can and then try to speak directly into it.
Jennifer Nicole Dozier.
Okay.
Smoking probably helps.
I can't remember the exact, but the night of this arrest for this case with Officer Jarvis here, do you remember that night?
At Dollar General?
Yes.
Yes.
When I was asked to get out of the car, I know you're saying your area of expertise. Do you believe that I pulled away from her or
objection,
pushed or gave her?
Not to my knowledge. You stated that you wanted a male officer because you didn't trust female officers.
Okay. Do you, was you ever, I'm trying to state this question the right way.
Starts with a word then.
Was you ever asked for your driver's license at the scene?
I don't recall.
You don't recall? So you don't know if you had, so do you know if she ran your name or?
I'm sure she
to
did.
see if you
They
had?
usually do on like recall.
Okay. Did you have a valid driver's license that night?
Yes.
Okay. I believe the last question I would have is that is there any reason that you believe that that you want to tell the courts of why I don't trust female officers at the words you said?
Yes, because we've had
Pull that microphone towards you closer so that at least we can try to hear you.
that a little better.
Okay.
Yeah, I mean, you said you had female issues with female officers before. I'm sorry, I'm struggling here. You said you had issues with female officers before because of that domestic, and the female officers all came out a long time ago.
Okay.
The female posse arrested him before.
I believe that's all I have for you, Your Honor.
All right.
No questions.
General Bryson, you have any questions?
No, Judge.
Thank you, ma'am. You may step down. You can have a seat in the courtroom, or you may go out in the
we all
lobby,
got
or you
some of
may
that.
leave. Mr. Vaughn, you may call your next witness.
Ugh. That was yucky.
Yes, Your Honor, I don't have any more witnesses.
All right. Now, I'll hear you in argument. This is your motion, so you may argue your motion to suppress.
Turns to his elbow, counsel. What do I say? What do you get when you mix an elephant and a rhinoceros? Elephino.
Can I stay seated here and argue it, Your Honor?
That's fine.
Thank you.
Hope she gets better soon. It sucks to have laryngitis. Fisherman's friend.
This is a motion to squash, to dismiss with prejudice, and suppress any.
We're going to squash this one.
Suppress evidence. Citations under the Fourth Amendment, under the Tennessee Constitution, Article 1, Section 7, and TCA Code 47103A1, and also under the Fifth Amendment for Mirandaization. Oh, this is one case.
Okay, so Miranda would be, you weren't informed of your rights. You weren't informed that you had a lawyer. You could request a lawyer. You weren't informed that you had the right to remain silent. These.
Okay.
Let's see if we can squash this one.
Resisting arrest is a charge that my lawful actions does not fit the crime, therefore should the counts be dismissed. State versus Burgess, quoting, State versus Corridor, concluding that the defendant's not moving and directing obscene language at officers were not sufficient to support a conviction for resisting arrest. Also see Tennessee Attorney General articulating that passive interaction, specifically sitting in a car and refusing to exit, was not resisting. Again, a lack of cooperation in service or process is not a criminal offense, quoting Burgess. The defendant has no legal obligation to facilitate service or process or other cooperation with deputies by accepting service or process, quoting Burgess. The officer had other means of effecting service or process available to them, but elect not to pursue them. His actions did not foreclose the deputy's opportunity to serve and to merely constitute a lack of cooperation with the deputy's chosen method of service. When a detention arises to the level of full-fledged arrest, the Fourth Amendment demands that the seizure be supported by probable cause. So a seizure occurs for probable cause under the Fourth Amendment when the police detains an individual under circumstances where the reasonable person will feel that he or she is not at liberty to leave. Hanks versus Florida. It says, the officer continues detention of the defendant in the back of a locked police car has ripened the investigation, stopping to an arrest, and the officer did not have probable cause to arrest the defendant at the time the seizure was illegal. United States versus Richardson. The police crossed the lines of the investigation into an arrest when they placed a suspect in the police vehicle for questioning ongoing beyond the bounds of a Terry, crossing into an arrest and constitution of seizure.
Richardson,
on the
Terry
night
stops. Good
the officer detained me, no force or resistance occurred. With or before the citation mentioned and the Burgess case stating force is physical and obstruction and arrest requires force to be used against the officer. Therefore, the arrest is illegal. Being compelled to accept service after myself and Jennifer stated we do not need your services is unlawful. The escalation should have been the prime intent of the officer of a domestic. The music was up to stop the argument over the birthday cake. The officer could have asked Jennifer to get out of the car to check her for injury since the concern was for her. These actions with her reaching in the window multiple times, placing me in fear was just as every other interaction with females responded to domestic, it's bias. State versus Daniels. However, neither the Fourth Amendment nor the Article 1, Section 7 of the Tennessee Constitution limits all contact between police officers and citizens. Instead, the Constitution provisions are designed to prevent arbitrary and oppressive interference with the privacy and security of the individuals. That's quoting D'Angelo.
He's making points.
So the State versus Dowie. Article 1, Section 7 of the Tennessee Constitution is identical in intent and purpose with the Fourth Amendment. Thus, these constitutional protections are implicated only when a police officer interacts with a citizen and impermissibly intrudes upon the privacy of the person, security of the citizen. That's my first argument for the dragging on rope. Do you want me to continue with all this, or do you want me to allow the state time to respond?
Well, that is your argument as to the resisting arrest charge?
Yes, sir.
Okay, I'm going to dismiss the resisting arrest charge, which I've already done before we ever began that hearing. So the resisting arrest charge was dismissed voluntarily by the state. So it has no bearing in this argument on this motion, except for whatever arguments you might make about how that impacts the validity of the remaining issues. Any other argument?
Yes, sir.
You have a driving on a revoked license that you're facing, as well as the retaliation for past action. Those are two separate charges, and you have the right to. I would simply point out to you that the resisting arrest charge. Well, I'll wait for you to. I want to let you conclude.
Okay. Also, I want to argue the fact that no exception to catch and release were explored because of the resisting. So, I believe I'm asking. May I ask a question to my sister?
Yeah. He's doing well, and he's got some, I would say, some strong points to argue. I don't know if he'll win outright, but he already won with the resisting charge down, but he had other issues. Saying that she never would have known that I was revoked if I didn't go to jail, not true. She could have run your license plate just, had you not resisted and not gone that route. I don't know if that was necessarily fruit of the poisonous tree. The officer was within her rights to stop and respond and investigate, and I think that would have been something that she found in due course under the regular, procession of the events. But she didn't, right? We'll see. We'll see what the judge says. You guys are saying fruit of the poisonous tree?
Your Honor, I believe I can read a little bit more of this, but I mean, it's already filed into the record. I mean, unless you want me to read it in open court, it's up to you.
I don't need you to read it, but you make the argument, as I've said, all of this that you've argued so far has had to do with resisting arrest.
Correct, Your Honor.
And if you want to address your motion to suppress as to the driving on a revoke or retaliation for past action, then I'll be glad to hear that. But as I've said, I've already dismissed the resisting arrest charge on the state's voluntary motion.
Okay. Well, the rest of these, the arguments I have also stem from the resisting arrest.
That's fine.
And I'm using the resisting arrest as a reason for that we should tainted fruits. Let me see.
Fruit of the poisonous tree.
Yes, sir. Let me just go ahead and read some of this. I'm going to go on and read some of the retaliation right quick. All right, for example, Mirandization is triggered only on custody. So once I was placed in the back of the police car, matter of fact, once I was placed in handcuffs, I was in custody. And Miranda should have fell into a factor. And
Miranda requires that the officer Mirandize you, if you want to say that term, that you be advised of your Miranda rights before any in-custody interrogation.
Correct.
Those rights include the right to have an attorney, the right to remain silent, and so forth. There is no statement that's been introduced at this point that where an officer has questioned you or interrogated you while you were in custody, and if they had, then without Mirandizing you, then the remedy is to exclude that statement.
Yes, sir.
But there is no statement. The statements that have been introduced were voluntary statements made by you, not as a result of questioning. That would therefore, Miranda would not apply.
Actually, it would, Your Honor. There was a question that was asked on the entering of the jail, and I have a case here. It's Travis Lester's versus United States, where it states that any encounter with an officer where they ask you any question is subject to Miranda, because any question that an officer asks can be considered as a listening and an illicit questioning that can be the fruits of a discriminating, I can't find my words.
The elbow counsel doesn't have them for you.
Incriminating response.
There it is.
So Miranda would apply in this case, and I have this case here too, if you would like a copy of this, put in the record.
I'm well familiar with the Miranda rights and how they apply.
The issue is that comment hasn't been entered as evidence.
me just read this. I believe this is good to be read in the court. It said, at no time was I informed of my rights, and I was questioned and answered at the alleged charges. Fear is not a factor when the officer is laughing and instigating the event. There is even a jailer stating, "You look scared" in the video.
We're going in circles.
It says, furthermore, charging me days after, which we already addressed that in the court. No.
I think if he can make the argument, he might win this. But I don't know if he can make the argument properly.
Your Honor,
Good elbow counsel. Resting one elbow on the table, the other one.
Before this clearly illegal arrest, the evidence and any statements used to make count 3 retaliation of past act never would have been obtained before that legal arrest. And also, I have a similar argument.
Is dismissing the charge equal to making it to admitting that this was an illegal arrest? I don't think it is. There are plenty of arrests where charges get dismissed, but
the fruits of the poisonous tree that stem from that arrest,
they taste good.
Which is the exclusionary rule, encompasses both the primary evidence obtained as a direct result of the illegal search or seizure and evidence later discovered and found to be derivatives of the illegality, United States versus Anderson. Quoting Serga.
These are core principles, like Law 101. You probably don't need as much case law on this.
Committed by the Fourth Amendment is fully accomplished by the unlawful search and seizure itself, and excluding the evidence could in no way cure the invasion of the defendant's rights which he has already suffered. That is United States versus Leon. Instead of seeking for repair of one of the Fourth Amendment right, one violated, the exclusionary rule aims to prevent future violations of the Fourth Amendment by removing the incentive and disregard it. That is Elkins versus United States. And that's all in support of the
first motion.
Fruits of the poisonous tree.
And all the others. I bet this guy, if he applied himself, he could pass the bar. I bet he could. It's clear he's done
State
enough.
versus Blair. The proper remedy for illegal arrest is the suppression of evidence seized as a result of the arrest, not dismissal of the indictment. It says evidence, State versus Dotson. Evidence derived from such a search is subject to suppression unless the state demonstrates by preponderance of evidence that the search and seizure was conducted pursuant to an exception of the warrant requirement. And I don't believe that the state will have enough evidence to support that finding, Your Honor. And here's my argument for the retaliation. The state lacks evidence of lack of an intent. They don't have a intent. They can't prove an intent on my behalf that it was actually directed at the officer. They can't prove that there was an intent
He got
to
too many
do harm
whacks
to
on that.
her. There was no proof of none of that. There's no proof that any retaliation even exists. The act wasn't even motivated by retaliation. Just her touching me and telling her to stop touching me, that had nothing to do with her official capacity.
But she's taking the handcuffs off you. There's some contact there for safety reasons.
The law requires that the retaliation be in response to an official act, testimony, an arrest, a prosecution. That was not the case here, especially when we just questioned her. She said that she gave me over to the custody of the jail.
You were still in her cuffs, though. She needed those.
If I wasn't unlawfully committed into the jail facility to begin with, this just wouldn't even been a situation. There wasn't any link between the officer and her official role. Lacked the intent. Oh, that's not the argument here. The officer wasn't intimidated, nor was the officer harmed.
He's doing pretty good.
And furthermore, the arrest wasn't even lawful, so the act of retaliation doesn't even apply.
I believe it was a lawful arrest.
And any responses that came out of me should be counted as emotional and not expressive, nonviolent, nor retaliatory.
Where's the case law on that? I don't want him to win because that empowers more pro se people.
So my prayer is that the court sees my argument and move to dismiss all of it as tainted fruits stemming from the arrest itself, Your Honor.
There's the argument. There's the motion. It's good.
All right,
State.
General Bryson, you may
Count three.
respond.
She yawns on the way up to the podium.
I'm going to approach this almost backward. The question that I see as almost deciding this is what would actually be suppressed here? So the state is going to trial on 2 counts, driving on revoked. So the evidence that the state would present in that is the officer seeing the defendant driving and the fact that his license is revoked. So no suppression would apply to either of those factors. Okay. The second count, or the second charge that is going to trial, is the retaliation for past action, which doesn't have to be actual physical retaliation. The threat of retaliation is what's being alleged here. And to follow the defendant's logic that, let's just say this was a legal arrest, which the state does not agree. But let's just follow that logic. If this was an illegal arrest, by the defendant's logic that his statements should be suppressed as part of a poisonous tree, had he instead chosen to punch the officer in the face and commit an assault, that should be suppressed as well. He is essentially asking for permission to commit new offenses. This is not an interrogation with a confession. It is a new offense. And under case law, even if this were fruit of a poisonous tree, even if we were following down that line, new offenses are not going to be covered by that. They are attenuated from the original incident. And so we just can't go down that road and follow that logic that his new offense doesn't count. Because that's essentially what he's arguing. It doesn't count that I said these threats to her, we don't end up there. That logic doesn't work. So let's go back to this supposed illegal arrest. The officer, as she stated under Pennsylvania v. Mims, had authority to ask him to step out to investigate. Probable cause was determined on 2 different occasions, both by the magistrate and the grand jury, for resisting arrest. Okay? The defendant's behavior, she is asking him to get out. She does have to lay hands on him. Judge, the state chose not to go forward on that charge because there's a difference between beyond a reasonable doubt and probable cause. But the officer had probable cause to make that arrest. And moving forward, she had probable cause to charge him for driving on revoked license. Now, the question here is not whether or not cite and release should apply, because that's not what the officer was dealing with that day. But looking simply at what the defendant is asking to suppress, none of the applicable legal doctrines would require suppression of those things. The evidence that she saw him driving and his driver's license was revoked, and then he committed a new crime. For those reasons, the state requests that you respectfully deny this motion.
Anything else, Mr. Vaughn?
Yes, sir, rebuttal. Let me hit on the driving on revoked first. The law requires that that once an investigation is ended, that once the reasonable time for an investigation is ended, it should have been ended. It should be. There's video proof that it took up to 29 minutes, which is unreasonable for a stop of that volume, Your Honor. And there wasn't proof of driving on revoked until after the fact. I mean, it's well on into the night. And then there's awful discrepancies in the system they're using to say that I'm driving on revoked. It's saying driving on revoked, but multiple times you can look through there and see that the charges are reinstated. And there's also a scene in the video where dispatch is talking to the officer and they're debating on whether my license are actually
Judge,
revoked.
I'm sorry, none of that has come into evidence.
Correct. Sustain the objection. None of that was brought forward in your argument, nor in your evidence, and none of that was played for the court, so I have no evidence to support what you're saying.
Is that not in my motion, Your Honor?
It doesn't matter whether it's in your motion. A hearing such as this is an evidentiary hearing. It's required that you produce proof on every issue to substantiate what you allege in your pleading. Pleadings are nothing more than allegations. So there's nothing in the record today that would support what you're arguing. I sustain the objection.
Okay, all right. And I have to reiterate that for it to be a past act of retaliation, that I have to say something directly to the officer or the victim, Your Honor. And there's not one person or any proof that they can provide that I actually stated something straight directly to anybody. I'm just freely talking. And for it being a new charge, there is no new charge to apply to something when I'm not talking straight to nobody, and I shouldn't even been placed in a situation to have to even fight a charge. If I wasn't even illegally arrested, I should have been cited and released, if anything.
I want him to do well in life and maybe even enter the legal profession with a little more schooling, I think. But I don't think he's going to.
I have one more word that slips my mind, Your Honor. That's all I have now.
Right. In considering your motion to dismiss or to suppress, the court has to view all of the evidence that's been produced here at the hearing. The evidence at this hearing is indicated for Officer Corporal Javins has testified to as the reasons for her initiating the stop of this vehicle were to investigate a domestic violence situation. She approached the vehicle and began speaking with you. She asked you to step out, or the defendant to step out. The defendant refused after repeated requests. Why is that important? Because the court is well aware of the fact that there is a a greater risk of violence or threat of harm to law enforcement in response to domestic violence cases than many other kinds of cases. But an officer who is investigating a scene has a right to request that a person step out of the vehicle. Refusing to step out of the vehicle, and according to what we saw, was what you could consider to be some sort of forceful resisting. The argument that there is no valid charge of resisting arrest because it's, of the circumstances, and therefore the fruit of the poisonous tree, so to speak, would apply, implies that there was, or assumes that there was an illegal arrest for that. 39-16-602 of the Tennessee Code defines resisting stop, frisk, halt, arrest, or search. And that, under subsection A, says it is an offense for a person to intentionally prevent or obstruct anyone known to be a person to be a law enforcement officer or anyone acting in a law enforcement officer's presence and at the officer's direction from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer or another. Subsection B, except as provided in section 39, TCA 39-11-611, it is no defense to prosecution under this section that the stop, frisk, halt, arrest, or search was unlawful. So it basically says that can be. Now, I understand the argument being made that you really didn't do much to resist, according to what you were saying. But there's sufficient case law that would support a finding of guilt, and that's really not the issue, because what we're dealing with is probable cause. Is there probable cause for an arrest? Don't confuse the fact that there is a lower standard for probable cause to make an arrest than there is for a conviction beyond a reasonable doubt, which is what you're arguing. Evidence was sufficient to convict the defendant of resisting arrest because the defendant ignored officers' orders to come out from underneath the vehicle and had to be dragged out, and the defendant then refused to place his arms behind his back so that he could be handcuffed, and the defendant struggled with the arresting officers before his investigator was able to place handcuffs on him. State versus Baker, a 2019 Court of Criminal Appeals decision. The application for appeal to the Supreme Court was denied, and that's found at Lexus at 2019 Tennessee Lexus 484, September 20th, 2019. So that, and that was supporting a finding beyond a reasonable doubt of sufficient proof for resisting arrest. In this case, the court is only concerned with whether there was probable cause for the issuance of the arrest, because if there was probable cause for the issuance of the arrest for resisting arrest, which clearly by this court's finding there was, then the argument you make about the fruit of the poisonous tree is actually irrelevant, because it does not apply. But in any event, the officer had probable cause to stop the vehicle, had probable cause to interrogate the passengers in the vehicle during an investigation for domestic violence. Why require the driver to step out? Because under the circumstances, with the type of charge, very easily that a person could have driven away and fled the scene with the victim of the domestic violence in the vehicle with him. Those are just concerns that the court is aware of that could have applied. They ask a person to step out of the vehicle sometimes for officer safety. There is nothing illegal about that. The resisting statute makes it clear that resisting an officer's directions to step out of the vehicle where you have to be dragged out make it a part of the statute. So even though the state is elected not to proceed on that charge, the fact of the matter is that there was probable cause for the arrest on that charge, and therefore, even if that charge was dismissed, there was probable cause that existed for them to initiate an arrest, in this court's opinion. As to the driving or revoke charge and the argument about cite and release, yeah, if he had stepped out of the vehicle and offered his driver's license to the vehicle without resisting, then he could have been cited and released at that point. The officer had probable cause to stop him and check his license and to check the circumstances during an investigation of the domestic violence, and could have checked his driver's license and allowed him to be cited and released. His actions on that scene, on that particular moment, are the very reason why that did not occur. As to the retaliation charge, this court disagrees with the interpretation that Mr. Vaughn makes of retaliation. 39-16-510 of the Tennessee Code provides for retaliation for past action. And it says, a person commits the offense of retaliation for past action who harms or threatens to harm a witness at an official proceeding, a judge, a district attorney general, an assistant district attorney general, an employee of the district attorney general, or a law enforcement officer, clerk, employee of a clerk, a juror or former juror or family member of any such person by any unlawful act in retaliation for anything the witness, judge, district attorney general, assistant district attorney general, employee of the district attorney general, or law enforcement officer, clerk, employee of the clerk, or a juror did in official capacity, and so forth. The offense of retaliation for past action shall not apply to an employee of a clerk who harms or threatens to harm the clerk, and that has nothing to do with yours. So the statements that have been introduced at this hearing the other day and today are that the defendant made the statement, got some bullets for all of you after he was at the jail and was upset about being arrested. The other testimony today as he walked into the jail with Corporal Javins was, I'm a threat for a reason. And then it was also testified that as he was trying to take the handcuffs off and be at the jail, that he made the statement, fuck no, I'm going to beat that bitch. This court is of the opinion that all of such statements constitute sufficient probable cause and sufficient evidence for the matter to go to the jury on a charge of retaliation for past action. Therefore, the defendant's motion to suppress, dismiss with prejudice as to docket number 336 is dismissed. Now, we have other motions. Those motions are not applicable to the case that's set for trial next week. I will allow Mr. Spratt, if you want to have a moment to talk to your client about arguing those motions today. They would be motions to dismiss as to the other charges. His other charges include docket number 462, 2021-462, an aggravated assault while displaying a weapon, reckless endangerment with a deadly weapon involved in counts 7 and 8. Counts 1 through 6 are aggravated assault. Counts 7 and 8 are reckless endangerment with a deadly weapon. And count 9 is possession of a firearm by a convicted felon. And the additional charge, indictment number 337, 2022-337, he is charged with simple assault, false imprisonment, disorderly conduct, and public intoxication. And then with 2024 CR 142, he's charged with failure to appear. So the question becomes, is the state able to produce the witnesses necessary for a motion to suppress or dismiss as to these other charges? Is your microphone on?
Judge, on 462, I need about 3 different officers. And one is in training, one is driving a truck and might be available by Zoom, but my preference would be just to reset that motion to hear at another date when they can all be present in person.
Well, we have later this month, of course, this trial is set for Thursday.
Objection, Your Honor.
Pardon?
Objection. Availability of witnesses is not a reason for rescheduling.
That's in your opinion. This court's opinion is we've heard the motions today that are applicable to your trial set for Thursday of next week. The fact that we have other motions that are filed that are for cases that are not yet set for trial, this court is of the opinion it is not prejudicial to reset those motions for another day. I'm inclined to set them on the 29th if you can get your witnesses.
Excuse me, Your Honor, we are still under the Fast and Speedy Trial Act. I put a motion for fast and speedy trial. Part of the act states that that is not a reason for a continuance.
I don't have a trial date on your additional charges, but we will certainly assign you a trial date. What I'm suggesting is that you have a trial coming next Thursday on the first of these cases. We can't try all of those cases under the same jury pool. For your detriment, it would be detrimental to you for us to bring a jury in out of the jury pool, select a jury, try the cases that we've talked about today, then turn around the next day, and that same group of people who now know that, the evidence regarding that charge are then asked to sit in judgment of you, let me finish, who are asked to sit in judgment of you. I can't trot in a different jury panel for cases, multiple cases, to try them back to back to back. I'm trying the one that the state has elected to go first. We will then select a speedy trial date for your other charges as soon as we finish trying that one. I would like to see how soon we can set it. And if we can go ahead and set it for a trial either this month or next month, if you can get your witnesses in. Well, this month would require a different jury pool. For that reason, it would have to be next month.
Does this county have a jury?
So we're setting a continuance for her witnesses, correct?
A continuance on your motions.
Yeah, that's the same argument. It ain't got nothing to do with the trial I'm talking about. The continuance just for the witnesses to be present is what I'm arguing.
Yeah. And what detriment to you is there for continuance of the hearing on the motions you filed when your cases that those apply to are not set for trial? How does that prejudice you?
Well, my witness is here today, and it just...
She's under a subpoena to reappear.
I understand that, Your Honor, but for her to keep on coming out of our way, I don't even know if that's possible.
Well, she's under a subpoena, so it is possible she will have to appear or she'll be in contempt of court.
Is there a way for her to appear Zoom if need be, Your Honor?
No, not under the circumstances. Well, if for a motion hearing, we might be able to do it by Zoom, yes.
Yes, that's what I'm asking, because the officer's allowed to do it. My witness should be able to, too.
I think if I allow an officer to do it, she'd have to be allowed to do it as well. And we'll be happy to set that up for her. And she's nodding, that's what she'd like to do, so we just need to make sure that she gives Mr. Spratt her information so that whenever these motions are set. I'm inclined to set the motions on the 29th. General, is there any reason you can't get your witnesses together on the motion for the 29th in the afternoon?
Of this month, Your Honor?
Of this month.
There's a high probability I'll be in Decatur.
Pardon?
There's a high probability I'll be in Decatur.
High probability you'll be in Decatur.
Judge, he has a circuit court date in Decatur on September the 30th. I don't know when they transport, but that's what he's expressing.
When does this guy have time to study law?
That Jimmy Reader PCR is going to go.
It sounds like
there's a possibility that we could do the motions first part of October, but I won't know that until after Tuesday of next week. So after Tuesday, the 23rd, I should be able to tell you if we can use the first or second of October for the hearing on the motions. What do you have, General, on those days?
Judge, I would be available that day, and I should be able to reach out to witnesses for motions that day.
Then let me determine on Tuesday, after Tuesday of next week, I can tell you if we can have your motions heard as quickly as the 1st or 2nd of October.
Right? Would that be by mail or?
Well, I'm going to have to let Mr. Spratt know first, and then we can notify you by mail if that's necessary. I want to get word to you as quickly as possible.
Okay.
About the order appointing some of this stuff, I'm not sure that I have the order appointing me, but I don't think I'm allowed to be compensated at all for this.
And we'll enter an order not pro tunc, because I'm almost certain I saw an order appointing you in this file.
And Your Honor, the way I read the Supreme Court rule is that Mr. Vaughn being the pro se first chair, that the Supreme Court won't allow for co-counsel. So the order is conflicting there. I believe I did at one point see an order that appointed me as counsel, but I don't think the court ever announced that.
Yeah.
Mr. Flanagan, Mr. Vaughn was here on the failure to appear that was ultimately dismissed. And the court, if I'm not mistaken, appointed me as elbow counsel that day, and then Madam Clerk's office sent a standard appointment order that I never understood to have any effect. I never understood that to have the effect of appointing me. I don't think the Supreme Court's rules allow me as second chair to be compensated in Class E, D, C, or even B felonies. I think it requires like a death penalty case or a first-degree murder case for co-counsel to be appointed.
You may be right.
And that being the case, I have volunteered since Your Honor's ruling, and I will be filing a motion in another case for Monday to have me designated as lead counsel under that rule in Ms. Stephanie Lowe's stead. But that being said, if I'm not able to be here at some of these dates, I've have quite a bit going on with transitioning into my solo practice and closing out some cases, and I have civil cases and cases everywhere. So I'm not trying to withdraw from Mr. Vaughn, but just say in the hypothetical, in the past when Mr. Baker and I have had cases, sometimes he might be here to argue them, sometimes I might be, and I don't mind coordinating a witness for him. It's just that I can't, I'm under an order that doesn't compensate me ostensibly in violation of the 13th Amendment.
Yes.
I like Mr. Vaughn, and I don't mind helping him at all, but
I'd like to get paid.
Let me review the file and we'll determine that. Obviously, we have a trial next week, and it's my understanding you're willing to assist him in that trial.
I am willing to assist him in that trial, yes, sir.
We'll determine the remaining charges at that point.
Yes,
and the law is where Mr. Vaughn has elected to represent himself, that the appointment of advisory or elbow counsel is completely within the court's discretion. He's not entitled to it. It's within the court's discretion. Frankly, reading Mr. Vaughn's pleadings that he has filed, he demonstrates a level of legal expertise that is unusual for a pro se defendant. And therefore, I'm not really as concerned now, having read through all of his pleadings as I was initially, that he's in need of advisory counsel. He seems to be very competent to raise all of the issues he wants to raise, and for that reason, it may be necessary to relieve you if you're not being compensated from representing him further beyond the trial next week.
Yes, sir. I do think he would need, I'm not volunteering per se, but I do think it would be beneficial for him to at least go through his first jury trial before we.
Let him get one trial under his belt.
Jury trial with you, then
before
the remaining jury trials, he would at least have some experience. So. All right, then we'll.
At that time, I will request for another elbow counsel if possible, Your Honor.
Now, that's the thing, as I just explained. If you elect to represent yourself, you don't have the right or entitlement to elbow counsel. I have the discretion, within my discretion, to appoint someone to help you. Now that you have filed all of these pleadings, and I've seen that you have a level of expertise in raising all of your issues, I don't find that you are necessarily entitled to have elbow counsel. You're representing yourself. That comes with the obligation that you be prepared to do everything that you're supposed to do. So Mr. Spratt will stay with you through this next trial, but I do not intend to appoint elbow counsel to help you with the remaining charges.
I object to that, Your Honor.
I understand you object to
The
it.
Sixth Amendment, I believe I'm calling the right amendment, counsel and as I see fit.
So are you wanting to have an attorney to represent
I'm
you?
still wanting to represent myself. I want to stay lead seat, but with assistance.
And as you heard me state, the Supreme Court's rules are that elbow counsel is advisory in nature only and completely within the discretion of the court. And to appoint an attorney who would have to then stay with you at no compensation, this court is not entitled to do that. You can hire your own lawyer if you want to. This court is not going to appoint an additional elbow counsel. So Mr. Spratt will stay with you. We will see you all on Thursday, if not before. So I'll let you know after Tuesday whether or not the October date will apply, although Mr. Spratt has indicated he will no longer be able to continue. So we're going to break for lunch, and that will conclude this hearing today, and the remaining issues will have to be scheduled for a future hearing. Make sure that that the witness that was here under Ms. Dozier has given the proper contact information, and we'll go from there.
All right, with that, they're done. That Mr. Vaughn made some good arguments there, and the judge was right in saying you're showing a level of legal expertise rarely seen among the pro se crowd, and because of that, I no longer have concerns about you representing yourself, and I won't appoint any more elbow counsel. So you're going to be on your own. He's like, wait, I want that. I have the right. The Constitution tells me I have the right to counsel. Yes, it does. Well, guess what else? We have conflicting rights in a couple places. You also have the right to testify in your own defense, and you have the right to remain silent. And those two also conflict. At some point, you have to choose between which right you would like to exercise, and you can't have it both ways. I think he'll do fine after get one trial under his belt, which he might even win. I will give him this. He may even win this one. I think he probably should spend about as much time as he's spending studying the law, which seems to be extensive, just, reviewing behavior and actions so as he doesn't get in trouble with the law, change his behavior. If he had put half of the effort that direction, we would never be here, and he might be a lawyer arguing the case for somebody else in Orange. I think he's definitely got the capability and the capacity to do that, but now that he's convicted felon and all these charges, that might negate that. But I guess next week we might be able to watch on this one. Well, depends how fast the sentencing goes, the sentencing trial or the punishment phase in the other trial. He threatened to shoot up the officers. It sounds like a threat. That may, I'm surprised that wasn't counted as a terroristic threat, where he threatened to shoot all of y'all, where it's basically coming in and shooting everybody. Typically, that's enough to meet that terroristic level, which tends to up it just a little bit. He was trying to make the taxpayers pay for him to go pro se, and they don't have to do that. Him running his mouth is the problem and throwing fists. Let's see, definitely want to see this one through, says Blue Star. I'm interested as well. Josh, is this one you could put on the radar? Keep us up to date on? The 29th, I think. Is that Friday? Does it start Friday? 29th is a Saturday. No. 29th, this is Sunday. Yeah, whatever the date was. I don't remember what the date was. He's doing impressively well. Quite well. We are suddenly vested. Yes, we are. I do like... I'm not coming just down against this guy. I think he's probably got some behavior issues. It seems unlikely to me. I realize innocent unless proven guilty. It seems unlikely to me that all of these cases in all these jurisdictions with all these different officers are just, they got the wrong person. Okay? He's got prior convictions. I think maybe there might be some meat to this. It's not just potatoes. There might be some meat here. I don't know. TikTok law degrees. A week on Monday. That's it. Oh, that's right. Because my gig's the 27th and 28th. Got it. So I think we should be able to follow this one. I think so. He had hearings on 9/15 and 9/18 from this court. Can we watch those if we're going to watch the trial? Possibly. My plan was to end early today. It's 3 o'clock right now, which is 2 hours early. That was going to be the idea. I'm not sure if... let me go over here. That was Sherrick Vaughn. Let me see what else he has in that one. Wiggins. There was one 3 days ago. That's 2 hours long. What was the other date? On the 15th, which was 4 days ago. Can't see the other one. I can see one. Let's go back and take a look at what it is. I'm not sure if we're going to stick around for the whole thing, but let's take a look at this one that happened 4 days ago. Same defendant. Judge comes in. No robe. Cut off a few minutes. Okay, here we go. All right. Little moment of prayer before court starts, and now we begin.
All right, we're going to take up a criminal matter that I need to address because we have a trial set for Friday. Upon the conclusion of this hearing on the criminal matter, then we'll come back to the Chancery docket. So, we got Mr. Spratt, are you ready for Mr. Vaughn to be brought out?
Defense guys, you need to move.
Maybe Ms. Duke wanted to take over as elbow counsel. So.
She's like, I'm out of here. See.
Come on, Mister.
All right. This is going to be the State of Tennessee versus Sherrick Markey Vaughn.
Just waiting for the defendant, then we'll begin. Different officer will be questioned on this one, but it might raise some of the same issues that we have already heard the results of. Kelly DD. Gifted a membership. Thank you very much, Kelly. Should we do it at 1.5? I'll try. Let's see how it sounds.
All right, this is the State of Tennessee versus Sherrick Markey Vaughn. We have he has, I think, 4 different indictments. The defendant has filed a number of motions, some of which are addressing to different of those indictments. The one that I'm going to deal with, Mr. Vaughn, for your information, the only one I'm going to deal with this afternoon is the case that is set for trial on Friday, and that is the docket number 2022 CR 336. Am I correct, General, that is the state's election to proceed?
Yes, Judge.
All right, so the case that's set for Friday,
that's a resisting
charge of driving a revoked license, third offense, of resisting a stop, frisk, halt, or arrest or search, and then count 3 is retaliation for past actions. So, well, I don't know, I don't recall you being told specifically which one we're being tried on, but that is the one the state has elected to try on Friday. You have filed motions on that case, and that is the one motion that you filed is the motion that I'm going to address today. So it's your motion, and I will recite, all filed in one.
Massive folder.
Number one, there was a motion addressing all of the indictments that was filed back in March for a request for a bill of particulars. Is that a case that we need to address that motion? Beyond that, we also have your motion to quash or dismiss with prejudice suppression. And that's the one that is specifically addressing 2022 CR 336, which is the case that's set for trial on Friday.
That's the one we did.
So let's start with that motion. It is your motion, Mr. Vaughn. If you want to address those issues, you can come to the podium and argue your motion.
Address one thing before we get into that, just because it will bring some clarity. The state was already planning to go ahead and dismiss count 2 of this indictment, which is resisting arrest. State will continue to go to trial on count 1 and count 3, but that should shorten the argument some.
All right, so the state is moving to dismiss count 2.
Yes, Judge, which is the resisting arrest.
So count 1 is driving a revoked license, third offense, and count 3 is retaliation for past action. Mr. Vaughn, do you understand that the state has moved to dismiss count 2 of this indictment? So
can you turn on the mic?
You need to turn your microphone on there.
For fruits of the poisonous tree, they need to dismiss the rest of them because that was the reason I was even arrested to begin with.
Well, I'm going to let you argue your motion, and
Your Honor, can I get a hand free so I can find my paperwork, please?
you may.
You might get both hands free.
Your Honor, while he's doing that, may I address the court? There was a motion to quash the indictment in this case, and a bill of particulars motion, is that right?
There was a bill of particulars that was filed, a motion for a request for a bill of particulars filed March 27th of 24. And that contained, addressed 4 different indictment numbers, including the one for Friday, 336. The motion specifically addressing 336 is a motion to quash or dismiss with prejudice / suppression. And that was filed July the 7th of 2025.
All right, that's the one you're here to hear today, you said?
That is the motion that I'm going to hear today.
Okay, you said you want me to
You
read
may.
Your Honor, why wasn't I given notice of today's court date?
Number one, you filed these motions, and this is the first opportunity that we have to hear these motions or this motion prior to your trial date. I'm assuming you don't want your trial date continued from Friday, since you had filed a speedy trial motion.
Yeah, and I'm still stating the same thing on the record, that that is not what we were supposed to go to trial on. The last time I was here, it was for the case in Dixon over with Jennifer's mom. I forget the case number. There you have the case number. She didn't speak about going to trial on this one. The state changed it without giving notice again.
I'm sorry?
I mean, it seems like it's a hindrance to my defense when I don't know what we're going to trial for when I'm coming in here, and I'm told one thing and it's another thing when I get here. And I'm not even giving notice that I'm here today. Like, I wasn't expecting to be here until Friday, and I just filed 2 more motions that would have made it on time within the time limit that's required by the local rules of practice. I got them with me. I'm kind of caught off guard here today. The reason I'm trying to get
What are
understanding.
those motions addressing, Mr. Vaughn?
It was another to recruit Mr. Lee Spratt, and it was another to address these charges here today, too, where there was some dismissals back when I first was arrested, and them dismissals still showed up on my Homeland Security report that it caused another arrest in another county. It was a motion to arrest judgment on that. That's, yeah, so I feel like I'm getting caught off guard here.
I don't think I give Homeland Security much reason to pull
Well,
my
your
record.
motion to dismiss or quash was filed, and this case is going to trial on Friday, so I have to hear it before the trial. To not do so would basically mean that your case would have to be continued, or you'd have to waive your motion.
No, I'm in full understanding of that. Yeah.
I'm trying to give you an opportunity to have that heard and make a ruling on the record of it so that, you preserve the issue prior to the trial date on Friday.
Okay, do you also have a motion for chief evidence up there with you?
A motion for what?
For the state's evidence in chief?
I think there is a motion such that you described, but it is not addressing this indictment number.
I should have one for all of them, and including with this, is the state not required to respond to me? Because I've responded way before the state responded. She didn't even give me a response to this motion. I'm just filing this, and
The state does not have to respond to the motion until they come to court. They can then respond on an oral argument.
And then I can have a response after that, correct?
Yeah, I'll give you a chance to respond after they do.
Okay.
But you do have a motion to preserve testimony or a motion to subpoena someone, and that is to subpoena Jennifer Dozier.
Yes.
From Savannah, Tennessee. Was there a subpoena issued for Ms. Dozier in regards to his? Well, he had requested that there would be a subpoena issued for Jennifer Dozier to make her testimony at the motion hearing date. All right, let's let you go ahead and argue the motions that you feel like are, there is a motion to preserve testimony or a motion to subpoena that was filed again on July the 7th, and you've included all three of the case numbers on that.
You said which one was that, Your Honor?
The motion to preserve testimony or motion, and then / motion to subpoena. Then you have a matter that you filed again on July the 7th called judicial notice. And this is where you're complaining about the discovery being delivered to the jail administrator rather than sent to you directly. And then we have the motion to quash or dismiss with prejudice.
That's Jennifer Dozier.
This should last almost an hour here.
Your Honor, can I go back to the table? Because all my paperwork's over there.
You can do that. We'll let microphone towards him so that we can make sure that he's picked up on the record.
Just move the whole thing.
All right, did you see what you needed to say?
Wow.
All right.
It's a file.
I want to deal with all of the issues that relate to 336 that are set forth. First one is the motion to preserve testimony or to subpoena this witness. So let's deal with that one first.
Jinx, we followed the verdict live. That was a couple hours ago.
I'm ready when you are, Your Honor. I'm sorry.
Yeah, he's asked you
I
to
believe that's
begin.
fairly easy.
Push that base of that microphone towards it.
Can you hear me?
I can hear you.
Okay. You're fine with me arguing from here, correct?
Yes.
Okay. I'm not saying my motion.
I'm ready when you are, Judge. I don't have my papers. Josh, I agree.
All right,
Prosecutor
hereby I,
Gibson.
Cedric Vaughn, come to move the court to subpoena Jennifer Dozier. I have her phone number, which is listed. Her address is also listed. To preserve testimony in the above case and motions to dismiss, she has first knowledge on each pending case. I move the court to subpoena Jennifer Dozier and make testimony at the set motion hearing date.
Granted.
This is the motion I filed for you.
Okay, why do you need Jennifer Dozier subpoenaed?
Well, Jennifer Dozier is the mother of my children, and we were also living together. And every time I was arrested, she was present at every scene, and she can verify to my testimony of each case, like the illegal arrest, non-resistance, illegal search and seizure, twice and two separate. She can testify to every single thing I'm stating.
All right, in regards to the case on Friday, which is basically a driving on a revoked license, third offense, and retaliation for past action, how does her testimony factor in on those two charges that we're dealing with on Friday?
On those two charges, I mean, I would say it would still tally in if we add back in the charge they're moving to dismiss, because like the motion states itself, that it'd be fruits of a poisonous tree, that they need to dismiss it because it was a legal arrest from jump. I should have never been put in handcuffs or arrested or nothing. And she would testify, I never resisted or anything. To take that one charge and just press it to the side and then keep the rest, it'd just be illogical.
Illogical?
Well, I understand what you're saying, that she may have been present during some of the proceedings, but is she going to be able to testify about anything that has to do with whether or not you were driving or not driving a motor vehicle while your license was revoked?
I feel like that's a trick question, Your Honor.
Yeah,
you're probably trying to perjure me, aren't you?
It probably is a situation where you don't, because you're representing yourself.
Don't answer.
Well, obviously, we cannot get a subpoena issued and served on her at this point in time. Do you have any contact with her?
I do, and she would be a material witness, Your Honor.
And being a material witness, then you would be entitled to a continuance for the case on Friday if she's not present.
How long is this continuance, Your Honor? I'm so tired of these cases. I don't want it to be out months at a time again.
Let me run through this. Right now, do we have State versus James Wills? It is a go. State versus Hansard. Is the Wills case going to go more than one day? So the Warren case is the one that I have the motion under advisement, but it is still set for trial.
What did you say?
State versus Sarah Fuson is still go. So we could set Mr. Vaughn's case for the 25th.
It's crazy that the judge has so many
September 25th
jury trials, and Judge Middleton has not had a jury trial yet this year.
Are you back from vacation?
I'm trying to think, Your Honor. I also have Decatur coming up.
Decatur's on September the 30th.
It's the 30th? Okay, that'll work. Is there any way we can also add in this other motion about getting heard about the Homeland Security stuff that was supposed to be dismissed?
Well, that really doesn't have any relation to what I'm doing today. What I want to do is deal with what I have to on this case, and then we'll set you another day for arguing the motions, because I just brought you in on a day when I'm supposed to be hearing chancery matters, which are not criminal, and I'm doing this in order to expedite the disposition of these motions. So what I'd like to do is to stick with the motions regarding this case and go from there. And if we're going to have to continue it anyway, then we can set all of the motions on, how big is the docket on the 22nd? About 49 pages.
And Judge, I will be here that morning, but I'm leaving at your lunch break.
Okay.
Could you do Friday morning?
What about, since we're not going to be able to go to trial general, what about having the motions for Mr. Vaughn's case heard on Friday, the day we were going to try the case?
That's what they're going to do.
I can do that, Judge. I'm trying to work around. I've got several officers that are no longer in law enforcement, and so would you be looking at putting this for trial on the 25th?
We will be setting the case that you want to proceed on 336 for trial on the 25th. What I'm trying to do. He has requested a subpoena to be issued from Ms. Dozier. He is entitled to have that witness subpoenaed. I don't find that there was one. Even I think it was probably just a series of motions that got filed and it just got overlooked. So I want to give him an opportunity to bring this witness in to have her testify if he thinks it's relevant. So.
Judge, I think I should be able to move all of my witnesses around. I would ask if we can agree that if a witness is out of town or something else, that they could appear by Zoom to testify, which would keep us from having another continuance, but still have witnesses available. Because I can't stop right now and see if everyone I've got is available. If we
but again, this is only going to be on the 25th for this case 336.
I understand. I've got one officer that is working in Cleveland. I've got another that is self-employed.
Self-employed officer?
I've got to work around a couple of different things.
I just choose to be a cop.
On the 26th, we have the sentencing in the second-degree murder case of Curtis Day, correct? Sentencing, Hansard Rule 412 motions, State versus Sheets motion to dismiss, to suppress. Hicks and Long.
That's me.
Well, my only concern is trying to set this case for the 25th and hear the motions on Friday. Can we at least agree to set the motions on Friday?
Yes, Judge, I have one officer that is present today that will be unavailable on Friday. Could we go ahead and preserve his testimony today?
Yes. I'm going to move your motions to Friday to give a chance for you to get in touch with this young lady that you want to have brought in and see if she will come voluntarily. And I'll have the clerk go ahead and issue today a subpoena for her at the address that you've shown in your motion. But they may not be able to get it served on her, but if you'll contact her, she can be served with it if she'll voluntarily appear. And we can set your motions for Friday.
Yeah, that's frustrating, Your Honor. I mean, these motions been in. I mean, that makes no sense. I mean, she's prepared, but I ain't.
Well,
that's very frustrating.
Resetting it to Friday is going to give you a chance to prepare, and you know
it
which
is,
ones.
but it ain't. It is, but it ain't. I mean, these motions been filed for 4 months. I mean, I don't understand why people just can't read the paperwork and do it.
Well, even by the record, they were filed July the 7th, so they're not been filed 4 months. Let me go ahead and just say that we're going to continue the motions to the 19th this Friday, and we're going to have the trial moved to the 25th.
How does he argue it both ways?
If, General, you may file your request to have a witness appear by Zoom according to the rule, and we'll have a hearing on that on Friday as well.
Well, if that's the case, Your Honor, can we go on ahead and get my other one added in too? I mean, because the reason I keep asking about this motion, this pertains to me in Decatur.
Well, let's just hear all your motions on Friday.
That sounds good.
Pardon? On every case, we'll hear every motion he's got.
That sounds great. That's great, Your Honor.
Turns out.
Count 2 is dismissed on the state's motions. They've acknowledged it.
Counting this one.
Day versus Wills. I did a motion hearing on that. Name is familiar.
How does he say these have been filed for 4 months? Why do these keep being put off? Let's argue these now. And then I'm not prepared, and she's prepared.
Yes, go ahead.
All right, thank you.
I'm going to go ahead and I'm going to switch gears and go to Chancery for a few minutes, and then I'll come back to you. But I know you've got an officer that needs to be heard, and we'll try to do that as quickly as possible.
Okay, we're going to skip forward. Wait for it. Chancery, Chancery, Chancery. Looking for orange, looking for orange. We're almost done. Wait for it. There he is. We're almost done. That was quick. Here we go. Zoom, zoom.
Judge, I need to update the court as to a procedural matter in this case.
Pull that microphone toward you a little bit.
Okay. Judge, I need to update the court as to a procedural matter in this case. Mr. Vaughn, in several of his motions, was asking about booking, and it occurred to me to double check something. So when this case was originally charged by warrant in June of 2022, the resisting and the driving on revoked were charged by warrant. The retaliation for past action was not added as a charge until grand jury, which was in October of 2022. Because we did not modify the bond, there was no new book-in at that point. I've not pulled up yet to see when he was arraigned, but he was later booked in on that charge
February of 2024 when he was booked in on everything coming into custody altogether. But the booking may have been after the initial arraignment, which is what I wanted to alert the court.
According to the docket sheet, he was arraigned on November the 30th of 2022, and that the plea date was set for April 3rd of 2023, trial date of April 6th of 2023. And he had an attorney on November the 14th that filed a waiver of personal appearance by Mike Flanagan, his attorney at the time. All right, then we're ready to go forward on the preservation of testimony regarding the motion that Mr. Vaughn has filed.
Yes, Judge. Is there any need to re-arraign him at this point?
Not that I'm aware of. Okay. The booking process is something that occurs at the jail for a person to be booked and processed according to the Sheriff's Department's records. This court speaks from its record, and this record is from the docket sheet, and the indictment that contained all three of those counts was arraigned, he was arraigned on that in November of 2022. Plea of not guilty to all of those was entered. He was at a waiver of personal appearance also by his attorney at the time. So I do not find that there is any defect in the issue of the validity of his arraignment, because he had an attorney that waived the reading of the indictment, and this has never been an issue that's been raised up till now. So for that reason, the fact that he was or was not booked on count 3, he was booked on the original charges and when he was taken into custody. So,
Judge, I realize we are not arguing the full motion, but so that you may receive this testimony in a meaningful way, I would like to give this court a very brief sort of factual summary of this case.
All right.
Oh, good. Background story time.
Judge, law enforcement came in contact with Mr. Vaughn while investigating a call out that Mr. Vaughn was the driver in a vehicle. In the vehicle was Ms. Dozier, who you've heard about today, as well as their 2 children. The officer asked to speak to Mr. Vaughn separately, and he refused several times. Ultimately, she opened the door and escorted him out of the vehicle. That was the basis for the resisting charge that was originally the reason for arrest. It was later found out that his driving license was revoked, and that charge was added since he was driving the vehicle. Now, once he was at the jail, he made several statements to law enforcement that are the basis for the retaliation for past action. And when we have the hearing, you will hear the bulk of those from Officer Javins. We do want to preserve the testimony of Lieutenant? No, Sergeant, I'm demoting you. Sergeant Stewart, because he will not be available on Friday. And so that he comes in after Mr. Vaughn has been arrested and is present in the jail and has already made some statements to Officer Javins, which you will get at a later date.
All right. You may call your witness. You may.
It clarifies the matter before it ruled on.
You'll come to the podium.
Yes, sir. So, the arraignment, and Mr. Flanagan waived the arraignment. I just want to clarify for the record that his bond was revoked, I believe, on all these cases in July of 2024, I believe.
MCAT, welcome. 31 months. Oh, gee. Where's all the time gone? Good to have you here.
July 24th of 2024, the defendant failed to appear in court. Present was the DA and his attorney, Lee Spratt. Mr. Spratt spoke with the bondsman. The bondsman could not find the defendant, issued a capias and hold for a hearing. Final forfeiture was set for January 17th, 2025.
And the capias was served. I just want to make sure that for the record that he's never been booked on count 3, that in the event that we get to a point that he's going to get jail credits.
And I would only point out to you that when the indictment came forward with a third count that he had not been booked on, there was no increase in the bond. So the bond that was revoked was the same amount that was put in place at the time he was arrested on counts 1 and 2. So there was no change in the bond. And I agree there might be an argument to be made about the booking process if in fact he had been arrested on a higher bond because of that third count of the indictment.
Yes, sir. Thank you, Judge.
Then, General, you may call your witness.
State would call Sergeant Justin Stewart. Did I get it right? Sergeant.
Sergeant, if you'll come forward, we're going to put him over here.
Are you Sergeant Justin Stewart?
Yes, ma'am.
Would you spell your first and last name for the court reporter, please?
Yes, ma'am. First name Justin, Justin. Last name Stewart, Steward.
And Sergeant Stewart, were you employed by the Dixon Police Department on June 18th, 2022?
Yes, ma'am.
And during that evening, did you work a call involving the defendant, Shariq Vaughn?
Yes, ma'am.
And you continued working that shift afterwards?
Right.
And you went to the jail for another call?
Yes.
Or after another call?
A warrant service, yes, ma'am.
And at the jail later on that night after his arrest, did you encounter Mr. Vaughn again?
Yes, ma'am.
Could you explain to the court what happened?
So at the time, I can't remember if I was a field training officer or a corporal, but either way, I had a recruit with me, Officer Floyd. We made an arrest later in the shift, and while we were at the jail to deal with our arrestee, jail staff pulled Mr. Vaughn, I believe, out of the holding cell he was in, and he was upset still at that point, agitated, and he made a statement, something to the effect of, I've got bullets for all of you, or enough bullets for all of you, et cetera. So I just mentioned to Officer Javins when I returned to the police department that was worth notating in her report, just in case in the future, if she were out in public, if you were to, attempt to follow up on those threats, the documentation would be there that they were made.
Nothing further, Judge.
Mr. Spratt or Mr. Vaughn, either of you have any questions for this witness? Come to the podium. And I would, again, Mr. Vaughn, I know you are pretty well acclimated to the law about a lot of things, but you must ask it in the form of a question.
Yes. Give me a second. How long ago was this case, Mr. Stewart?
2022. It's been a while.
2022. So you have full, you remember, have no problem remembering what happened?
Yes, as I said, me saying it, the phrase or the terminology of enough bullets for all of you or names on bullets or things like that, I'm not 100%. I do recall it being concerning enough that I went back and told my officer to document it just in case you actually meant it and weren't just, upset in the moment and may actually try something later.
So that's what you're standing, you're sticking to it? Like
100%.
You're fully remembering
Absolutely,
that?
yeah.
Do you have any video footage of this?
So we're working on that right now. We initially thought that my video footage was tied to Officer Javins' original case with you, with the traffic stop. And then it was learned recently that, no, in fact, my footage was not from me being present for her case. It was a separate case that we had afterward while Officer Javins wasn't at the jail.
So you don't have any footage?
Of my own body cam at that time, no.
Okay. Is there any jail footage that you know of?
I'm not sure. I know, as I said, Officer Floyd was there with me, and then, of course, some of the jail staff would have been present.
Okay, and you said they pulled me out of the cell, and I made these statements?
If I'm not mistaken, I know you were standing in the area in front of what is now Male Detox 2. They have a blue square on the wall to photograph people. I don't remember if they had just pulled you out, but I remember you being out of the cell in the open there when it was set.
Okay. I rest, Your Honor.
Yep. Go ahead.
A moment, Your Honor.
Yeah, consult with your co-counsel.
The judge says, you don't rest yet. Your co-counsel said, wait, ask these questions. Man, I just saw the post from a good friend who says, I got to ring the bell symbolizing I've completed my chemotherapy treatments, and I'm just so excited for him. It is awesome. I mean, chemotherapy has been miserable. And, it takes you to death's door sometimes.
Yes.
And hearing that he's done, I'm just so excited.
Mike, is it?
Hope the scans are great.
Sergeant, I'm sorry. I always want to clarify. You said that he was pulled out of the cell and made the statement, I got bullets for all y'all, right? And that's exactly how he said it?
Yes.
Okay. So he never mentioned Officer Javins specifically then, did he?
I don't think he explicitly stated it was her. It was just law enforcement.
All right. So, did he say law enforcement?
The only other people in there would have been law enforcement. So I just logically, yes, that's who he's talking about.
All right. But none of them are named in this indictment, correct?
I don't believe so.
Okay.
Anything else, General, for this witness?
No, Judge.
All right, thank you, sir. You may stand down.
Thank you.
Okay.
For the purposes of the hearing today, we were preserving all of the other
I'm going to pause
motions
this for a second.
Friday, and this was only to allow Sergeant Stewart to testify and preserve his testimony to be considered by the court at the hearing on Friday.
Hang on 1 second.
So if there's nothing else, then we'll adjourn this case
I'll let this
until
finish.
Friday. Mr.
We can't hear him. Mrs. Ari just went shopping, and she just said, Guess how much milk costs?
That's a good question. I'll allow you to review the file and make that determination.
It's 97
Your Honor,
cents a
one more.
gallon
Would you
for
consider
milk in North
those
Carolina right now.
motions that you probably haven't received yet? Consider those as moot.
How much was chocolate milk?
I have, except the motion of indigency. You can keep that one. I just don't want to add no more time to the fast and speedy trial. So if we can't get them heard, I just want to consider them as
If
moot.
you have motions that you're going to file, make sure
your
that
milk
Mr. Spratt
orders in
assists you
now.
filing them, and we'll have everything heard.
I'm going to swim in it. I'm going to
They're
fill a
already
pool.
considered filed by the rules, sir. Once they're put in a correctional facility now, they're considered as filed.
You want what?
Considering the Rule 49, they're already considered as filed. I'm just trying to get them considered as moot today.
As moot?
Well, I'm not hearing anything else today to allow you to have an opportunity to prepare everything to be heard on Friday. Since the trial date is being moved, we're going to give you the whole day of Friday, if necessary, to hear your motions.
All right, thank you.
All right.
Be careful with that
Anything
milk.
else before we adjourn?
Get me 10. I'm going to fill up my
We
freezer.
stand adjourned tomorrow morning at 9 o'clock. We'll have Chancery resuming again, so we'll hopefully only have Chancery and not.
All right, and with that, they're done. Seriously, we've been paying. North Carolina always had cheaper milk for some reason, like dirt cheap, right around $2 a gallon, and suddenly it just whole milk. $0.98 a gallon. Great value whole milk, vitamin D, gallon, plastic jug, 98 cents. What is wrong with the milk? I'm going to go try some. How much? What else is on sale right now? Everyone come to Greenville, North Carolina. Buy your milk here. 98 cents a gallon. It's worth the trip. I have $6 for half a gallon, says Camilla. Good excuse to make some real pudding. I tell you, we're going to have cereal all week long. Let's break out the Oreos. It's $4 something here in Washington. $3.50 in Missouri. Milk's expensive. 98 cents a gallon. Since when was anything under $1 at the grocery store? Except for like noodles, like mac and cheese and maybe ramen. 98 cents and 67 cents a gallon for chocolate milk. Let's see. Let me verify that one. Chocolate milk. Nope, it's also 98 cents. They're both 98 cents. I was wrong. 62 cents for a half gallon. 98 cents for a gallon. Woot woot. All right. So that's $7.99 here for 2 liters. I think I need to start a new business. I need to rent an industrial sized trailer, buy all of Walmart's milk and wait a week and then sell it and triple my money. Fact checking, Mrs. Arabra, who do you trust? Kelly, I just wanted to see it with my own eyes. Milk is something that hits close to my heart, right in my stomach, actually. But drink it all today, expires tomorrow. I'll check it, but normally they're pretty good that way. Grocery store made a mistake. Gonna get an upcharge on your debit card. It's not an upcharge because we buy 8 gallons regardless. So 8 gallons a week. Well, I know what I'm going to do this weekend. Actually, I do. I'm just not going to tell you till Monday. I'll tell you Monday what I do this weekend. How about that? Is that fair? I'll tease. We've got some plans. We got something we want to do. $2.43 in Ohio. That's more like the normal price. $2.25, maybe $2.35. 98 cents. Maybe you could get some chocolate milk and ship it to Thomas's wife. Oh, should do that. I wonder though. She might drink a certain brand. Like only the store brand, Great Value brand, is on sale. Like Moolah brand is still $5.12 for 1% low-fat chocolate milk by the gallon. So, all right. Now that I'm just thrilled to go have a milk bath and maybe a milk food fight or something. Gallons is a lot of milk, but there's a lot of us. We eat all week long. Is a milk bath even a thing? I don't know. It probably isn't. All right. That's all we've got for today. we're going to wrap up. It is 3:30. It's an hour and a half early. Apologize for that, but it does give you a head start on the weekend. I'm going to tease you and wait till Monday. Yeah. I'm really milking these. Oh, I see what you did there. See what you did there. Tell you what, maybe I can give you the dad joke of the day. What did one elevator say to the other elevator? I think I'm coming down with something. There you go. Now it's done. What store is that? Walmart, but not the murder one, just the neighborhood Walmart. Red Pen, I will look at the new thumbnail. I'll have to update all the old ones with that one. I know you've added the emojis. That's going to look great. And we're done. We're done. Are we going to watch Monday? Yeah. We'll watch something. Sentencing doesn't start until Wednesday. At least the sentencing portion of the trial, the penalty phase. But it probably will end Wednesday as well. Maybe even a verdict. We'll see. Happy birthday to whoever's having a birthday this weekend as well. Great weekend. It's only that one location in Greenville. I'm headed back there. I'm going to buy some more. Pay cash so they don't know it's me. They can't say you've already bought your quota. All right, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe till we go live again on Monday morning with more Court Watch. Super excited for everything this weekend, especially the milk. So you guys have a great weekend. You're all amazing. We'll see you. Be good to each other. Have fun. And I think some people owe me a phone call right now. You know who you are. Now would be the time. So, off air. I did just get a call. You saw me on the phone. Some lady trying to hire me. Apparently, she thought I was a different Scott, for managing a company that makes explosives. That sounds interesting. But anyway, you guys have a good weekend. We'll see you. Adios.
Because he's the guy.
There's nothing in the order that restrains you from talking to cats.
Well, thank you. What more do you need to see?
It's bigger than you. It's bigger than me. It's bigger than all of us.
Thank you, sir. You're my new best friend.
Hush! Now I'm trying to have court. You don't raise your voice again.
I don't like podiums, Your Honor.